This is a current events case brief with the case citation of R v. Freer 2017 ONCJ 623. The facts in the case are presented. Gary Freer is charged with the offense of speeding on the 8th day of September 2016 on Highway 89 in the town of Minto, Wellington. The trial commenced on December 14, 2016 and continued until March 2, 2017. On September 8, 2016, the investigating police officer was operating a fully marked OPP cruiser on Highway 89 westbound in the town of Minto. At 10:04 a.m., he observed the appellant operating a 2005 Volkswagen Passat motor vehicle traveling eastbound at 114 kilometers per hour, according to two readings obtained on the radar that he was qualified in operating. Gary Freer was operating 34 kilometers over the speed limit. The officer stopped the appellant, issued concern and penalty for his speeding. Mr. Freers felt that the officer demanding that his car be pulled to the side of the road violated his human rights. Gary Freer also presented a void driver's license and testified that his driver's license was signed correctly and has a witness, but is saving the witness for his appeal. The judge reminded the appellant about the case out west, referring to the well-known decision of Meds v. Feds 2012 ABQB 571. This case has been the subject of much judicial consideration and approval and is adopted also by this court. The appellant was found guilty by the Justice of Peace and was presented with a small fine of $238 and no demerit points taken away. The following issues in the case are presented. The Highway Traffic Act applies to only commercial vehicles, while the appellant was only operating at private convenience. The appellant was put into servitude as a result of being pulled over. This act is not aligned with the Canadian Charter of Rights and Freedoms and violates the United Nations principles. The appellant signed his driver's license and tickets without prejudice, leaving such a driver's license and ticket null and void. The decision of this case was that the appeal was dismissed in the circumstances presented. Rationale. According to the case, the appellant was reported driving 34 kilometers over the legal speed limit of 80 kilometers on Highway 89. The Highway Traffic Act, Section 128, provides that no person shall drive a motor vehicle at a rate greater than 80 kilometers per hour on a highway. On this grounds, the appeal was dismissed. This was taken out of context and suffers from poor legal information and advice and interpretation. This ground of appeal also fails. As previously stated, Mr. Freers testified that his driver's license was signed correctly and he is his witness in waiting. Without proof of witness, the grounds of this appeal is also dismissed. Safely operating a vehicle is a very tedious act. Laws are put into place for our drivers to keep the public safe as well as themselves. Gary Freer was caught speeding. This act was correctly punished as Gary Freer put citizens' lives at risk. The law in this case respects Section 1 of the Highway Traffic Act and the earlier decision of Meds v. Meds, as well as R v. Duncan appeal that dealt with the same offenses as the present cases that were presented with similar arguments and all concluded the same. The survey question as presented. Do you feel that a no demerit point reduction and a $238 fine is reasonable for speeding 34 kilometers over the speed limit on a central highway?